Good afternoon. I want to thank everyone for joining us today. My name is Lindsey McKay, and we're going to be speaking a little bit about estate planning basics. Whether or not you have your estate documents currently updated or are just trying to get an idea of where to start, our objective for today is to give you enough information to start thinking about what would be best for your circumstances, but likely you'd have some questions and would need some guidance. So whether that's working with us by starting a conversation or going directly to an estate planning attorney to work with them to get the planning done, we just really encourage you to take this information as a starting point to review your existing estate planning situation, or if you're starting from the very beginning, just really where to get the ball rolling. Quick note that we do have a question and answer box in the bottom middle of your screen. So if there's anything that comes up while I'm speaking that you have a question on, I encourage you to throw it in the Q&A box and we'll either address it live, or if it's something that's specific to your individual circumstances, we'll follow up with you directly. So mention briefly, this is for educational purposes. You'll see that as we go through the conversation, there are kind of legal steps that need to be taken in order to have your estate planning documents in order. And so we encourage you to seek the advice of an estate planning attorney. If you do not have an estate planning attorney that you currently work with and would like us to refer you to one, we have a handful of wonderful attorneys that we partner with and can definitely connect you with someone that would be appropriate for your circumstances. So, if any of you have ever had a loved one pass away and had to help them deal with settling their affairs, you know that there is a process that occurs after an individual passes away. So, the most basic idea is that an individual owns assets, and whether that's a bank account, a car, a home, when I pass away, I'm no longer able to be owner of those. So, how does the ownership of those things in my life get transferred to the individuals that I would like them to have? So at its most, kind of basic level, that's what the process of estate planning is figuring out not only who do I want those things to go to, but what's the most effective way to have that transfer of ownership occur. So it is a legal process, and we'll talk a little bit more about the different steps of that. But I think the biggest thing is that the state is going to be involved as far as how those assets are going to get moved over to who we ultimately want to receive them. And so the question is, how much planning or have we done ahead of time that enables us to proactively control that, or how much of it is just done based off of what the state laws would dictate? So you'll see here it's a court supervised system. It's initiated in the jurisdiction where you were residing at the time of your death. So that's important because you could have um, property that's happening in the state that you're living in, but you could also have property outside of the state, and so then that would have different state laws that would be applying to it. So what we're mostly going to talk about today is Washington State, but any state where you own property, you need to make sure you've done proper planning for that state as well. Personal representative manages the administration. So I mentioned before, if you helped a loved one through this before, you know what that role is, and it can be complex. And so the more planning we do ahead of time, the easier it can be for that representative to administer settling the estate. And it can be something where we want to be really mindful of who are we putting in charge of that, because a lot of times we'll want to just say, um, it's going to be, all my children together are going to figure it out. That's not necessarily the best plan because of the challenges that it can create to navigate. So we're wanting to think about one person that we're listing to be the administrator of the estate, with secondary people in can be in line in case that person is unable or unwilling to do it. And then probate. I think this is one of the things that we get the biggest questions about, is that people want to avoid probate. And so we're going to talk next about what probate actually is, but Just briefly, probates when we have assets that are in our name that have no beneficiary designation to them or no joint ownership. So I owned it individually, so there's nothing tied to it. And now that asset needs to get passed to another individual. And if in that case, it goes by my will, which goes through the probate process. So we'll just jump right into probate. Already said that first line. It's the process where the court supervises the transferring of your assets. It's really going to be getting us through the start to finish. And so really it's going to matter more what our will dictates than what we've necessarily have listed. So if we have nothing in place, there's nothing that's been on there, then that's going to be where the court's going to have to look through it and do it. So let's get into what helps us with getting assets change the title of ownership. So account title and beneficiaries, I already mentioned briefly. That's where if it's jointly owned, the other joint member or members are going to be able to take over ownership. So that's something that's going to happen automatically. If there's beneficiaries listed, so retirement accounts have beneficiary designations, or we have transfer on death or payable on death designations. That's where, again, we're going to have those assets are going to be able to transfer. So those pieces are going to actually occur, those transfers are going to occur outside of our will. So back to what would actually go by the will through the probate process, that's where we have those individually owned assets, things where there's not going to be a legal system in place that's going to already transfer that ownership, or we could have a trust. So in a minute, we're going to talk about both the will and the trust and how those operate differently, and how the probate process is impacted by that. We're also going to talk about so when we think about wills, that's something that happens when we pass away. Trust can be while we're living, or it can be triggered when we pass away. But there's also documents that are going to be are relevant while we're still living. And so that's going to be when we think about more of these disabilities. So I'm unable to continue to be in charge of my finances, or I'm unable to be able to be in charge of my healthcare directives. And so who do I put in charge of making those decisions for me? So when we think about the full estate planning process, a lot of times we think about, who do we want to settle the legal side of our affairs, but there's also the health side that's a really important part to think about, as well as the financial side. So I mentioned earlier, when we have multiple family members, it can be challenging to think about, how do I prioritize who would be in charge of what? And a lot of times we say, well, let's just make it fair and we'll have sort of everyone be involved in the process. And again, I encourage you to, as would an estate planning attorney, to think about, are there certain family members or relatives that would be better suited for these different roles, and not necessarily have it be something where I'm trying to have everyone, be able to have a say, because that can create some challenges. So back to the will. As we mentioned, without one, if I pass away and I don't have anything in place, then the state is going to decide who gets my assets. And there's a very clear kind of lineage of what that looks like. And so if you currently don't have any estate planning in place, you would want to think about if I were to pass away, what would the process be for the state to decide who receives my assets? And so it could be that you're fine with that process, because it'd be, if you don't have children, then it's your closest living siblings. If you don't have any living siblings, then it's your parents. There's sort of this, direct line, and it goes down. And you could say that that's fine for my circumstances. Just know that it also still creates challenges as far as extending the process of settling the estate. So even if you said, I'm fine with what the state would decide and I don't need to be involved in the process by setting anything up ahead of time, just know that it creates additional complexities and costs if you don't have a will in place. Another thing that you would stipulate in your will is guardianship for minor children. And so this is one where for most people who have children and young children, you already kind of know who you want that person to be, but it's really important that it gets legally documented in that will so that it doesn't create any challenges within the family members as far as who they think um, should be in charge of raising the kids if something were to happen to you. And then it also is an opportunity for tax and legacy planning. We're going to talk a little bit later about the tax side of estate planning, but there's a lot of things that you can put in place that trigger when you pass away based off your will so that you don't have to create it in advance. So your will is really a document where you can say, I've decided all of these things that I want to occur once I pass away. But rather than having to proactively set them up ahead of time, like some trusts, it might be something where you can wait and have it trigger upon your passing. So we're going to talk a little bit more about that tax and legacy planning piece as well. But I really think the point there is that it's an opportunity to manage some of the tax liability and then an opportunity, if necessary, to continue to have some control over the assets after you're gone. And I'll expand upon that in a little bit further. So think about this as our will is the things that if we don't have titling on the account that would cause the assets to pass directly, if we don't have beneficiaries on the accounts that would cause the assets to transfer directly, then the will comes into place. So one of the ways that we can title the accounts to have them avoid going through probate, go directly to the individuals that we would want them to outside of beneficiaries, is to create a trust and have the trust own those assets. So a lot of times we get questions from people around, do I need a trust? Should I have a trust? I hear about trusts. And the question is, it depends. It depends on what your goals are that you want to achieve with your estate. It also depends on what your objectives are while you're living. So a revocable living trust is the most flexible option of a trust that we have. What that means is that I'm setting up a trust where I continue to have control over the assets. The assets are still tied to me. I can make changes to it at any point that I want. I can be the grantor, the trustee, the beneficiary, meaning the money's still all in my control. I'm fully able to make any adjustments or changes. But the assets that I put into my trust are then going to be passed by my trust document. So that typically means that I'm going to have a successor trustee in place. I'm going to have a listed beneficiary or beneficiaries, or if you were going to be the beneficiary to start, successor beneficiaries. And what that does is it allows us to say, in the case that I were to pass away, these assets are going to pass based off of the legal document, the trust document that's already been created, which again would supersede the will. So I'm carving out this money and putting it aside, and I'm kind of creating all the parameters around it that I would like to have in place. The thing that I would call attention to on this one at the bottom is that it must be funded. So we have come across a lot of people where they, for whatever reason, have created a trust. They have a trust document, but they never put anything into the trust. So unlike testamentary trusts, which are created when I pass away and my will triggers what goes into those trusts, this trust, if nothing's in it and I pass away, then the trust was actually had no use or benefit. So we really want to be mindful about making sure that we are putting assets into the trust. Now back to some of the questions that we asked earlier of, well, what's our primary objective for this? Our primary objective could be a lot of different things. It could be that it's just the ease of transferring the assets, avoiding probate. It could be that we want to have some layers of controls in there. But if we look back and say our primary objective is a handful of those things, if it's ease of transferring assets, if it's avoiding probate, then we need to make sure that we have majority of our assets that don't already have separate designation of beneficiaries or separate title that would transfer to other individuals in that trust. So the one that we see most frequently that is not put in a trust that perhaps should be is your home. So if you have all of your accounts set up so that they either have beneficiaries or they're going to directly transfer from a transfer on death designation or a joint title ownership, whatever it might be, all of that stuff could transfer. But if your house is still individually owned by you and you pass away, then we're now back in the situation where it's going to trigger going through probate. And we touched on probate very briefly at the beginning, but like I said, most people are asking about if probate can be avoided because it's a long process and can be costly. So probate, it happens in the state where you pass away or where you own assets. So it could be happening in multiple states at a time. Um, and it can take, on average in Washington, it's taking 9 to 12 months for an estate to close. And there's an expense to doing it. There's expenses that have to be filed with the courts. You typically need an attorney to do it. So depending on the complexity of the situation, it's, costing anywhere from $2,000 to $10,000. So a lot of this advanced planning that we're talking about doing, sometimes people are hesitant to do it because they feel like there is a high cost to working with an attorney. Um, but I would suggest that, some of it being done in advance can actually be really cost effective and minimize the challenge or extra pressure that it could put on the administrator of your estate to be doing it all after the fact. So beyond cost, I think the other reason why people don't get very far in the estate planning process is that it's really hard. It is hard to sit down and think about, well, what happens and when I pass away. What happens if my spouse is still living? What happens if my spouse predeceases me? We kind of want to make sure that we're making all the right decisions, and it can feel so cumbersome that we stall and don't make a lot of progress. And so at the end, I'm going to share some resources that we have that will help guide you through sort of the process of thinking about it. And then also encourage you to sit down and have a meeting with us. Like it's a great brainstorming conversation to sort of go through this. What are my objectives for my estate plan? What do I ultimately want to achieve? Talk through some scenarios and really sort of feel like you've narrowed down what you want to accomplish so that by the time you're going to meet with an attorney, you've got a very concise idea of what it is that you ultimately want to achieve. And then they can help you to say, great, legally, here's the best way that we can set things up in order to accomplish those goals. So we talked about revocable trusts as being the ones that are most flexible and you get to continue to have a lot of control. It helps you avoid probate. But one of the considerations that we have around that is that it does not get assets out of your estate. So when we think about the roles of trusts play in our estate planning, it could be that we're trying to get assets out of our estate for tax planning purposes. And so if that's the objective, a revocable trust is not going to accomplish that. We would need to look at an irrevocable trust. And an irrevocable trust, just as the name sort of clues you into, is that we cannot make changes to it after the fact. We're giving up control of those assets. And so it's a much more kind of a bigger step to be taking. Then you want to make sure that that's something that's been thoroughly thought through and really making sure that the money that you're putting over there is set up to accomplish the goals that you still have during your lifetime, but then also beyond. So again, these are conversations that you would start to be thinking about with depending on what your objectives are. Would a revocable trust be applicable to my circumstances? That's most commonly used, but there could be circumstances where an irrevocable trust would also make sense for a portion of the money. So those types of trusts, revocable and irrevocable trusts, are established while we're still living, and they need to be funded. So I mentioned that was a kind of a critical part of that trust planning is to make sure that assets go into it. Testamentary trusts, on the other hand, are trusts that are created by your will. So they're not created while you're living. They are written into your will so that they would trigger upon your passing, and then we would have trusts that get created at that point for the distribution of your assets once you've passed away. And it could be a portion of them. Typically, it's not necessarily all. But what you can see here are some of the reasons why we would have testamentary trusts get created. Estate tax exemption, so tax planning. We see that most frequently when we have two people and married couple. One of them passes away. They could pass all of their money to their spouse, but then that loses the exemption that they have for taxes, both at the state and federal level. So we're going to talk about the taxes in just a minute here, but there's a way where you could say, I want to protect my exemption by putting those assets into trust when I pass away. My spouse can still use them for whatever they need during their lifetime, but I'm protecting the exemption, right? So I'm wanting to make sure I'm carving those assets out and putting them separate so that they're part of my estate as opposed to flowing to my spouse's estate. So it's a little bit like the idea of that irrevocable trust, right? There's sort of a limitation of control in there. Your spouse is able to use the money during their lifetime, but they're not able to change some of the specifics on the trust there, which can also be handy when we think about that second bullet point, which is providing spousal income while protecting beneficiaries. So we see this a lot in blended families. So if you have children from a previous relationship and you've been remarried and you say, of course, I want to provide for my spouse for any monies that they might need, but I don't necessarily want my spouse to be able to change the beneficiaries. They could get remarried. They could lose contact with one of my children, whatever it might be. I want to actually protect the children as well. I've heard an attorney refer to this as an I love you but trust. I want to make sure I'm provided for you, but ultimately I want to make sure that the funds that are in that trust are going to my children, my grandchildren, whoever those beneficiaries might be. Providing for minor children or special needs beneficiaries. I think this is one that's also really important when we think about people that aren't able to make financial decisions for themselves due to age or due to disability. Or even just we have people that there could be some challenges with receiving a large sum of money, and that would not be beneficial to their lives because of the extra stress that it would create for them to manage it because they're not good at handling money. There's various reasons where we would want to potentially provide some extra layers of protection. So it doesn't necessarily need to just be minor children or special needs. It could just be the circumstances of that beneficiary where you want to set them up in a way that it would be successful. Trust is a great tool to do that. But again, we don't need to set up a trust while we're still living. We can do it as a part of our legal planning. And staggering distributions, that's one where we want to put some age requirements on when money would be available to some of these beneficiaries. That's one that comes up a lot with clients asking about how do I put some parameters on it. A trust is the way that we would do that. So again, when we're thinking about who's going to be receiving our money, how we want them to receive it, and how we can help it be a successful scenario for them. Trusts are a very important tool in that piece, in addition to the tax management side. So unlike though our irrevocable or revocable trusts, which avoid probate, these trusts do not. So again, we got to think back to what's our primary objective in our estate planning and where would different types of trusts potentially be beneficial. I'll also say, since I keep mentioning probate, that people like to avoid probate, but it's also just part of the legal process and not something that I think should dictate all of your estate planning. So if we're meeting with an estate planning attorney and we're working on doing a lot of these stipulations in our will, as opposed to doing it in trust prior to passing away, I think that it's important to remember that we should be able to use the probate process. That's what it's there for. So I just mentioned that so you don't feel like it's something that should be avoided at all costs. Power of attorney, these are the documents that you have while you're still living. So this can be for financial power of attorney. It can be for medical power of attorney. And so it's, again, important to think about when do these trigger. So there are some that would be happening as soon as they're put in place. There's others where there's certain requirements or contingencies that have to be met before those that power of attorney goes into effect. So we want to be mindful of who are we putting in charge of this and what are the events that would make it be so that it's active. So we're finding more and more with clients that if they have these, they're outdated, and so it's important to review them. I would say every 5 years is sort of what, from a financial institution side, we like to have these documents up to date, and be mindful of too that if you are have assets, property in different states, are there requirements that are going to be different state to state? So again, that's where an attorney can be really helpful in helping to identify what type of planning you need to do for your specific circumstances. Healthcare directive, that's one where you can put your wishes for how you would want to have your medical choices made for you in advance of actually getting to the point where they need to be made. This is extremely helpful for family members who are put in the role of having to make those decisions. So, if you want to have a do not resuscitate, or if there's going to be life support needs, how do you want that to be handled? Are there they can get really specific as far as how much, I want to be able to be given fluids for hydration, but if I'm not eating, I want to be restricted to only things that are going to be done through IV, or maybe not. Maybe if I get to the point where I'm not, able to consume food, then that could be something that is um, something specific that you have beliefs around that you can say, here's where I draw the line, if you will. And then I think it's important that you share those wishes with your family as a whole, even if we've decided on one person to be making those decisions for us. So earlier we talked about sometimes there's certain family members that are better suited to make decisions in different places. Um, but still sharing with the family as a whole so that we don't put that individual in a spot where they're making the decision based off of what your wishes are, but the rest of the family are, sort of unaware that that was what you were wanting in that circumstance, and so then it's a difficult space for them to be in. So again, just more communication around that I think can be really helpful. Okay, we mentioned that part of estate planning is to help minimize taxes. And so there's different ways that we can utilize trusts in our lifetime or trusts at our passing that would allow us to minimize taxes. So let's talk about some of the taxes and what that looks like. So I think that helps to know whether or not trusts are needed. You'll see here on the federal level, the current lifetime exemption is almost 14 million per person. So for many of our clients, there really is not going to be a concern about a federal estate tax issue under current tax law. Just know that tax laws are changing all the time. So the current tax laws set to sunset this year. There is an expectation that there would likely be an extension or some form of a new tax law to extend some of that. But if it reverted back to the previous um, law that was in 2017, it would be closer to 6 million per person. So that would be a situation where we would potentially be getting a lot closer to having some federal estate taxes when we see it cut in half per individual. So ways that we can decrease some of the money in our estate is annual giving to family members. So this is not charitable giving. This is gifting to family members or friends, and the annual amount that you can gift increases slightly each and every year. And the current amount is 19,000 per person. So if you and your spouse wanted to gift to a family member, you could do 38,000 combined. And so that can be a really helpful tool over time in order to kind of maintain your estate balance or try and slightly decrease it over time by doing gifting. You'll see when we look at the 2025 Washington estate tax that the gifting probably becomes a lot more beneficial at that level for some people. It's actually set to increase July 1st this year to 3 million. And so the combined amount would be 6 million. And so by the time that we add in real estate and investment holdings, we have a lot more clients that are, in that space that are saying, okay, I need to be thinking about trying to stay under that $6 million combined threshold in order to avoid paying taxes at the state level. So we'll look at the actual taxes in just a minute, but for the federal amount, I already said we're able to, you can transfer as much as you want to your spouse without any tax consequence. However, we want to make sure we're being mindful of not losing that exemption. And so at the federal level, with it currently being fairly high, it might not be that big of a concern to protect the exemption, but at the state level it could be. So we don't necessarily want someone to transfer all of their assets to their spouse if that combined amount is going to be more than 3 million, because remember, as an individual, we're really only going to be able to use that 3. Apologies for that. So I was just explaining that the marital deduction currently probably is a lot more applicable at the state level. But as the tax laws change in federal level gets adjusted, something that we'll definitely want to make sure that we are um, keeping track of. So that sort of is a good reminder to say that we need to review and periodically update our estate planning documents. So it's another thing where we can help you determine whether or not there is going to be a need to make a change to your planning or something to revisit with your attorney. It could be that your personal circumstances have changed or that the tax laws change. You move states. I mean, it could be a handful of things that we want to be thinking of. So for those of you that do have your plans in place, we just want to make sure that it's something that we are continuing to talk about and being mindful of. The same thing is going to be true of beneficiaries. So for anything that you have a beneficiary on, we sort of addressed this earlier, but it's reminding you that the beneficiary is going to supersede what states in your will. So if you have things that you are looking to accomplish with the planning that you do with your attorney and you have outlined that in your will, we want to make sure that that matches up with the beneficiaries on the accounts that you have, the titling of your accounts, whether or not that's for your investment accounts, your bank accounts, retirement accounts at an employer, your house, which we already briefly touched on, but all of those things we really need to make sure that we are everything is set up so that it's working together, not in conflict. The other thing is that we want to make sure that it's clear what your most recent will has been. So if we're making changes to them and adjusting them, we want to make it so that the family knows which is the most current or will that you have. And so that's something else that is helpful for you to review with us so that if something happens down the road, we can let them know, well, here's the latest copy of the will that we have that was dated November 2024. So that's the most recent planning that they did. Charitable deductions. So we always talk about if there's people that are charitably inclined, are there desire to do charitable giving in their estate planning. That's another piece that needs to be thought of. We talk here about that's a way to reduce your taxes. So monies that are going directly to charity aren't going to be taxable to your estate. So if you're above some of those thresholds, there is going to be some tools, annual gifting we talked about to family members, without below the limit, annual gifting to charity. That also helps to get money out of your estate. But finally, you can still do it in your estate planning documents, that will side to say, there's a desire to be philanthropic and then determine what that looks like um, in order to reduce some of the federal estate taxes or state estate taxes, which we're going to look at in a minute. Let's move to that now because I think that's probably more applicable to most people on the call. So, as I mentioned, it's 3 million per person for the state of Washington. So if we said we were protecting everyone's exemption amount, it's a total of 6 million that you could have an estate that wouldn't be taxable. After that, here's how the brackets of tax start to build up. So the first million up, so again, if we're assuming we were able to utilize the full 6 million, the 6 to 7 million, that's that $1 million is taxed at a 10% tax rate. The next million after that is 15, and so on. So you can see that it pretty quickly gets up to that maximum amount, and the income tax or state tax on that could be relatively high. So there are other considerations for when we have high taxes or even minimal taxes that we know that we're going to have to be paying from the state estate side, and liquidity. How are your beneficiaries going to be able to pay for those taxes? So if you have a lot of real estate, for instance, that's something that's not liquid, and do we want people to need to sell it in order to pay for the taxes? Are we trying to continue to have a real estate portfolio where there wouldn't be funds available through that in order to pay the taxes? So therefore, we need to have liquidity in other spaces. There's sort of this putting all the pieces together where we can help you look at that. From some of the other assets that you have, good news is that they're, while it could still be taxed at the state level, you don't have the gains that get taxed on some of your assets depending on how they're owned. So that can really help on the tax side too, getting a step up from your value of your home, right? I have so many clients that they tell me, I bought my house way back when for $200,000, and today it's worth, substantially more than that, right? That's a lot of taxable gain that can be built up in there. And assuming that that's titled in your name individually, then you get the benefit of getting that step up in value when you pass away. The same can be true for some of the stocks or investment accounts that you have. So another way that we can help you in your kind of estate planning process is to look at what's the full tax consequence of the estate and how do we want to be thinking about that. And I will say, since we're talking about taxes, that a lot of the assets we're talking about are ones that are outside of retirement accounts when we're talking about step up in value, real estate, things like that. But your retirement accounts, your traditional retirement accounts, the taxation that's tied to them because you haven't paid taxes on them yet, so are separate than the estate taxes we're talking about. So again, when we're thinking about planning and trying to look at this full picture of things, we're not only thinking about the estate tax part of it, but there's still also going to be, kind of income taxes that are associated with those retirement dollars that had been deferred and taxes have never been paid on. So how we can help, I've mentioned a couple of times throughout the conversation that we can just help you get a better idea of what your picture is, I think is where we can start. So what are the things that you really should be thinking about? What are some of the planning opportunities? And then really taking that a step further and saying, let's go through some of these scenarios to decide what it could look like when you go to do your estate planning. Because I think that's one of the bigger challenges. People say, I'm just not really sure what I want ultimately. Like, how are we going to get this all figured out? And so we don't end up proceeding with the planning because it feels like it's going to be expensive to go talk to the attorney, and the attorney is going to ask us questions that we don't know the answers to. And so, how can we help you feel better informed and prepared before you go have that meeting with an estate planning attorney? The other thing that we can do is provide you that kind of one-page summary that shows all of your accounts that you have, either, with us, outside of us, your real estate, any titling that's listed on those. Is it already trust owned? Is it individually owned? Is it joint owned? We can also create a beneficiary report so you can say, of these accounts, here's the ones that have beneficiaries tied to them, whether that's through a transfer on death designation or a retirement account that already has beneficiaries tied to them. So I think again, the more information we can arm you with to go into that meeting prepared, and have all of your details on hand, that can really help to streamline it. We also have an estate planning worksheet that's intended to help ask or guide you through some of these thought sequence as far as what do I want to accomplish, what are my top priorities, and how would I balance those against one another so that we can hone in on some of that target, what I'm ultimately looking to accomplish. And then we have a really robust, we call it, it's kind of a family planning document where once everything's in place, like how do we outline it and put it in a way that it's going to be really easy for our family to know what assets we own, what our medical history, we things such as like I have a military record, so I'm, would be eligible for VA benefits, passwords. Here's where to find my information for online access, things like that. So that's one that is really comprehensive and takes a little bit of time to build. So I kind of tell people to chip away at it slowly over time. But I think that that's the other thing, that so much of the planning that people do or the information that they have is spread out in so many different areas that as a family member coming in, it can be really hard for them, whether you're still alive and just unable to give guidance for whatever reason or have passed away. How do I know where to find this information? And so I think that that can be a really valuable tool as well. So I think that, the bottom line is if you think that you would like to review your estate planning, if you know that you need to review your estate planning or you need to start your estate planning, I think we're a good place to start the conversation, because we know a lot about your financial situation and can kind of help to figure out which path you really want to start going down, as well as being able to refer you to legal professionals that can help you with that planning piece. So I know we had some questions come in, and I appreciate your patience as we worked through some of the technology challenges. So I'm just going to look through them real quick. Someone asked if there would be able to get a copy of the slides. Yes, we can provide slides to you, as well as a replay will be available. So if there's something that you wanted to go back and listen to again, or if you wanted to pass it on to someone else, a family member or friend who might find the information beneficial, we can get that to you. A question about the taxes, are they, how do they work? And so let's go back to this one is, yep, so what happens is that first million is taxed at 10%. The next million on top of that, once we're after the exempt amount gets stacked on there, it's at 15% now. So it's not 25, right? So the first million is 10, the second million is 15, the third million would be 17. It's sort of it's tiered that way. So it does build up, as it goes. But once you reach that maximum amount of 35%, everything above that is taxed at 35%, and the federal amount works that way as well. And then the question is about, property owned in other states. So I think that's a good question as well. Is that, is it taxed in the state where it's held? And the answer to that is yes. So it's not necessarily taxed by Washington state if it was held somewhere else. But then you have to keep in mind that if it's held outside of trust, it's going to have to go through the probate process in that state separately from probate process in Washington. So there's state estate taxes. So if it's held outside of Washington, the question is, would it be subject to, the estate tax at that state level, but then your full financial picture would be taxable at the federal level. So if you own properties in a bunch of different states, that all gets added together for what goes to the federal amount. Um, and then we had some questions around minor children. And it was particularly around grandchildren. And so having grandchildren be the beneficiary of assets and what challenges could that create? And I think that's a really good point to make is that, anytime anyone's under the age of that the state um, has listed them where they would still be a minor can't own a lot of these assets directly. And so there would need to be set up in a trust account, or if it was not set up that way, where it was going into a trust account, then there would need to be someone that's, listed as their legal guardian and responsible for that financial asset until they reach the age of majority. And so that's really important when we're thinking about not only how we're listing grandchildren in our wills, but also for listing them as beneficiaries on any of our other accounts. So, the age of the individual is something that's really important to consider, both on the young end and on the older end of the spectrum. We have quite a few clients who get up there in age and are listing then their siblings, let's say, as their beneficiaries. Well, if you're in your late 80s and your beneficiaries are older than you, then we have to think about, well, if the money flows to them, who then are their beneficiaries? So that's something else to consider, that we don't necessarily want to have our beneficiaries be too young, but we also want to make sure that they're not at an age where they're not going to live that much longer, and then the money would actually go to someone else. If we want that money to go to their beneficiaries, perhaps we just bypass that and list whoever it might be. Maybe it's a cousin or someone else that would be ultimately the beneficiary. So definitely something to think about when we're trying to decide where these funds ultimately might go. Um, the other question I have is, this retention of old legal documents. So if I have updated my estate planning documents, what do I do with my previous estate planning documents? If you updated with the same attorney, it could be that it's just that there was, some additional documentation that went, and it's all still sort of with that original estate planning or piece, and so nothing would necessarily need to be done. But if you've had a handful of different wills that were prepared by different attorneys, then it can be beneficial to make sure you're only retaining the current one so that there's no confusion as far as which one is the most recent. It doesn't happen all that often, but you do hear stories where multiple wills get filed with the state, and then the state has to determine which one is the most current, or which one is the most legally sound. So it's another thing that's really important about all these documents, is that they have to be signed in order for them to be legally binding. So a lot of times, there could be a family member, created their own will and did something, that they found online, or, some type of simple template that they were trying to do. But unless it's signed and witnessed, a lot of times it wouldn't necessarily hold up in court. So we just want to make sure that if we're taking the time to do all the planning, that we're making sure it's legally sound and not anything that could be disputed at the court level. So I think that that's everything that we had from a question standpoint. I'm sure that this gets a lot of thoughts going for each of you about your own circumstances. So if there's anything that we can do to help beyond getting copies of the slides and sending out that estate planning worksheet, please don't hesitate to reach out to the team. It can be straightforward, but there's still a lot of sort of small considerations to make. And so, I think having the conversation or reviewing the plans in place never hurts, just to make sure that there isn't anything else that should be thought of or considered. And it is a really important piece of your full financial picture, because you've worked so hard to earn this money in the first place and then maintain it and grow it over your lifetime. And so we want to make sure that we're being really intentional about how it's going to transition to, kind of the next generation or the next beneficiary that's going to be receiving those funds so that it's one, easy for them, and two, tax efficient. I think those are some of the biggest things. But then, beyond that, how are we making sure we're kind of thinking about scenarios and playing them out so that we're protecting not just the money, but also the individual that's receiving it so it doesn't create bigger challenges for them in the future. So with that, I'll once again thank you for your patience as I lost connectivity there. I appreciate you continuing to stay online and look forward to chatting with each of you about your estate planning situation and seeing if there's a way that we can make sure that it's the right setup for you and that no changes or revisions need to be made. Have a wonderful day. Thanks so much.